Hello, my name is John Hughes. I'm an estate planning lawyer here at McLane Middleton. Just want to tell you about how to get your affairs in order. A lot of times people use the phrase estate planning. I prefer to use the phrase getting your affairs in order. It's more descriptive and more specific to what we do here at McLane Middleton. Getting your affairs in order consists of more than just a last will and testament. A last will and testament is a method to transfer assets from you at the time of your death to the people that you'd like to receive them. But it actually falls far short of what needs to be done in terms of getting your affairs in order. Where we start with getting your affairs in order is the disability aspects of this process. The first thing to consider is who would make medical decisions for you if you could not do so for yourself. The issue is that no one is in charge without proper documentation. In New Hampshire, the proper documentation consists of a durable general power of attorney, a living will, and a HIPAA release. Massachusetts is virtually the same with the exception of the durable power of attorney for healthcare is called a healthcare proxy. The issue is that you need to address who is in charge of making those medical decisions, and that's the document that will facilitate the direction as to who is in charge. Anytime that we name a primary power holder, we would be looking to name a backup power holder as well in case that individual is also sick or hurt. The next aspect about getting your affairs in order is the financial aspects. The management of your financial affairs, the business of life, so to speak, needs to be managed in the event that you are either sick or hurt. There again, that's a document called a durable general power of attorney. When you name an individual to make those decisions, it's often a good idea to name a backup. So to get your affairs in order from a disability point of view, you want to address who is in charge of your medical affairs, and secondly, who is in charge of your financial affairs. Both of those documents should name a primary and a contingent. And in some cases, it's often advisable to name a third if, for example, you choose an individual who is of a senior generation, such as a parent or an aunt or an uncle. It would be wise to name someone of an even generation or perhaps a generation that follows. The other side of your estate plan is what happens when you die. You should have a last will and testament. The last will and testament can direct the assets and the inheritance of your assets at the time of your death. The problem with the last will and testament is that it's subject to probate. So probate is a very difficult process to manage. It can be very time consuming and quite expensive. So in today's world, rather than write a last will and testament that would direct the inheritance of your assets, what we do is we utilize a pour-over, it's P-O-U-R, pour-over last will and testament. What that does is direct all of your assets to your revocable trust. By doing that and having a pour-over will and a corresponding trust, the process of probate can be waived. So even if probate needs to be opened, the process itself can be largely abbreviated by waiving probate administration. That is available to those individuals who properly establish a will and a corresponding trust. Now, the trust that you want to utilize would be a revocable trust. It means you can amend it and restate it anytime you want for any reason or for no reason at all. A revocable trust is in essence the same as your last will and testament. Your last will and testament would be subject to probate. A revocable trust is not. So it allows the process to proceed without the oversight of the court. How your revocable trust is drafted is really up to you. And every person is different, so we need to discuss specific questions with each client to determine what's best for them. My job as an estate planning lawyer is to interpret the client's intentions and instructions and to put them in the proper format in the revocable trust to see that those intentions are carried out. At the end of the process, we need to then visit the beneficiary designations for IRAs, 401ks, and life insurance. Those assets will pass at the direction of those beneficiary designations. So it's important that those beneficiary designations are properly coordinated with the revocable trust. At the end of the process, the idea is to have all of the individual's affairs in order, such that in the event of a death, the assets can be properly directed, or in the event of a disability, that the right persons can have the necessary authority to make the right decisions at the right time, as life brings different events, and it's important to have the authority vested in the proper people. The process consists of first meeting with an estate planning lawyer, determining what needs to be laid out and the proper documents that need to be put in place. My practice is such that prior to moving forward, I would be able to tell an individual client the exact cost and the exact timing before starting. So that sounds like a lot, but getting your affairs in order is a very important part of life. And if it's done properly, it can be put in place for quite a long period of time. Typically, clients, once they put their estate plan in place, would not look at it for a period of about 5 years. Most individuals, if life goes as planned, can establish an estate plan at a young age, where their children perhaps are young or they themselves are young. And then later in life, many decades later, could address it again and update it as necessary. So that's how you get your affairs in order, and that's how we address estate planning here at McLane Middleton.